So this is a topic that I've been teaching and writing about for about 30 years, not as a legal scholar and not as a philosopher, but from the perspective of political science, international relations, and history. This might be the last time I talk about it, because I'm going to make the argument that the impact of international law and ethics on constraining war is diminishing now over time, to the point where we really have to think about other alternatives if we want to do something about war. So what I'd like to do today is break the discussion into four components. The first talks about the religious origins of certain concepts that have come into international law from the just war tradition. Then a short history of strategic bombing, where most of those principles were violated in the extreme. Then in the post-Cold War period, the 1990s and 2000s, we had debates about international legal issues because we thought that the law was having a greater impact on constraining war. But now we're at this point where we are questioning the value of the enterprise altogether. So let me start with the just war tradition, its religious origins, and then some of the main concepts. These will be familiar to many of you. How many of you, by the way, do have an international legal background or legal background? Okay, so this will be familiar, I think. I mean, starting with the religious origin. So who are these two guys? I'll give you a hint. There are metro stops named after each of them near the Università Cattolica del Sacro Cuore, where I've taught for about 20 years on this topic. Okay, so one is Sant'Agostino, the other is Sant'Ambrogio. Why are they important? Ambrose was the Bishop of Milan who invited Augustine of Hippo to come to Milan, where he converted to Catholicism. Later on, went on to write various philosophical religious works in which he introduced some of the notions of the just war tradition. 900 years later, another important figure developing some of these concepts. We don't really know what any of them look like. Aquinas might have looked like that, who knows? So here's the question: why did they care? Why did Catholics, for example, care about developing a tradition of just war? Anybody know? Why was this a preoccupation of theirs? Because of these things called the 10 Commandments, and one of them in particular. And if you look it up using the search engine I did, you won't learn anything very useful, except that there's an Italian television program called Thou Shalt Not Kill. But that's what they were concerned about. If the commandment is do not kill, people get killed in war. How could it be justified to engage in war? So this is what they were exploring, and what they came up with is two different elements. One is the justice of the war itself. When is it permissible to engage in war? Jus ad bellum, and I never studied Latin, so you'll have to forgive. Well, no one knows really how it was pronounced anyway, but jus in bello refers to the means of war. And within those concepts, the most important idea for justifying the use of violence is self-defense, or even better, defense of others, of innocent others. So the idea is that in order to prevent an evil, you have to engage in a certain amount of evil. Those are for the ends of the war. In terms of the actual fighting, the combat, there are also rules, and these are familiar to us, that non-combatants should not be directly targeted. What's the difference, by the way, between a non-combatant and a civilian? Are they synonyms? Are they the same thing? Exactly. So the category is broader than civilian. It can be soldiers and sailors who have been surrendered and captured, or who have been wounded and are hors de combat. We use the French term. So they are also protected. And as you think about the current wars, you realize how little people like this are protected these days. The other main point is that civilian harm should be proportionate to the military benefits, the proportionality principle. And very much related is this notion of double effect, which we see from other domains besides warfare, but it's quite important here. And you'll notice the language is this kind of religious language of good and evil. So the argument is that the act is good in itself, a legitimate act of war. And for those of you who may be principally nonviolent, it's hard to think of the good act as killing somebody, but if it's killing a soldier within this framework, an enemy soldier, that's considered good. That the direct effect of the act is morally acceptable, so it has a military purpose, that the intention of the actor is good. So if civilians are killed, that's not a deliberate goal, that's a side effect in a way of the good act, and it's an unintended consequence to harm the civilians, and then that the good effect has to outweigh the bad effect. That's the proportionality principle. Why is this relevant? Why is this religious tradition relevant? Is it only for people with names like mine who have to pay attention to the just war tradition, or is it somehow broader? It's obviously broader. First of all, there are many religious traditions that have the basic principles, especially the protection of civilians who are not directly involved in the hostilities. But the other point is that these principles have become part of international law, and we use the same language of proportionality of ends and means, of in bello and ad bellum criteria when we talk about international law. So for example, the 1949 Geneva Conventions have been ratified by 196 members of the United Nations. Is that a big number or a small number? That's a big number. That's all of them, plus the Vatican, plus Palestine, whose status is still as a member of the United Nations. So that's a lot of countries of various religious traditions or mainly secular who nevertheless maintain a commitment to these principles. So here's an example from the United States. So the idea is that you have an international treaty like the Geneva Conventions. The obligation is for a state to incorporate the principles into their military law, into their rules of engagement. So in the United States, which signed the Geneva Conventions, like everybody else, these have been incorporated into military manuals and then rules of engagement. And the rules of engagement are literally written on cards that soldiers carry around with them to tell them what they're allowed to do. That's the kind of the best practice, if you like, or the aspiration that they'll do that and that they'll follow those rules. So those are for the in bello rules, what they're supposed to do in combat, what the rules of engagement are. What about the ad bellum principles? Are they found anywhere in international law? Does anyone know? Hint? Right, it's the Charter of the United Nations, okay? And I have to put my glasses on for this one, hang on. So the Charter of the United Nations has been considered by some lawyers to outlaw war. So that's a pretty strong position on the ad bellum rules. You can't fight wars, okay? And you see it at the very beginning here, Article 2, for all members shall refrain in international relations, not only from the use of force, but from the threat of force. That's a pretty strong provision. Now, if you know the rest of the charter, you'll say, well, wait a second, isn't there an exception? That was an exception in the just war tradition for self-defense. And yes, there is. And so there's an argument between the international lawyers, does the charter ban war or does it not? What's relevant here is Article 51 that says nothing in the present charter shall impair the inherent right of individual or collective self-defense. Okay, so the people who say, no, it doesn't it doesn't ban war. Moreover, it says it's an inherent right to self-defense. We don't even need any laws to say that states have a right to defend themselves. But then, as often happens with these legal texts, you read on and you say, well, if an armed attack has occurred. Self-defense is very constrained. And after all, it's Article 51 compared to Article 2. So that suggests something about what the founders of the document were thinking in terms of trying to outlaw war. More recently, the use ad bellum restrictions have found their way into another international institution. What is that? My hint, right? And that's the document. Thank you. And now this is a very strange one, as you know. It came quite late after the Cold War. It was anticipated in the UN Charter, but because of the Cold War conflict, it was never implemented. But now the document has an article banning the crime of aggression. And the crime of aggression has all of the features that you would expect: bombing, blockades, attacks, and so forth. It's a very nice document, like many of these legal documents, but there are some things that you have to know about it. The first is that the International Criminal Court was intended to prosecute individuals, so individual criminal liability, and only for 4 categories of the most serious international crimes, one of which is aggression. So the statute was adopted at Rome in 1998. In 2002, the International Criminal Court came into effect, was established. Only in 2010 was the crime defined. So the states that signed this Rome statute were signing on to prosecute the crime of aggression without knowing what it was. Okay, so in 2010, the definition was adopted at Kampala. There are 125 states parties to the treaty. Is that a big number or a small number? Biggish number, but if you think about the countries that are not parties, then maybe the bigness of the number is not so important. Only 49 signed on to the amendment with the definition of aggression, and 0 is the number of individuals who have been prosecuted for aggression, even though we've seen plenty of it. Okay, so that's something to think about. If you find that depressing, you'll find this history even more depressing. So and Italians might feel particularly sensitive to this, because there was a very important figure who helped do away with the norm against harm, deliberate harm to civilians, and that was Giulio Due. So we'll mention him briefly and then talk about how enthusiastic many air forces were about implementing his ideas. So he had lots of things going for him, but he's most known for this study, The Command of the Air. And he made arguments that focused on what he called the inescapable conclusion: technical developments will provide no effective defense against determined efforts to bomb our cities. So he expected that a future war would be very much emphasizing the deliberate destruction of civilians right at the outset. And there were major figures in the United States and Britain who shared his views. The important thing to note, among some important things, is he thought this was a good thing. Okay, why? He thought it was important to terrorize civilians, and that it would lead to more humane wars in the future. What on earth was he thinking? Well, imagine that he was writing in 1921. What was the model of a war that he had in mind that was less humane than this? It was the trench warfare of the Great War, when young men were slaughtered by the millions. Due's idea was that if we threaten mass destruction of civilians, we can actually prevent those kinds of wars, because his notion was that the civilians would not put up with that kind of punishment and would force their governments to withdraw from the wars. He was wrong. He couldn't have been more wrong. But that was his claim. And what's strange is that people still think this, despite the history that I'm going to show you right now. This is the short version of it. So we start with the German participation in the Spanish Civil War and the bombing of Guernica. And it's become well, you know what it's become. It's become the poster for our course in Picasso's painting, but it set the stage for the increasing evisceration of this norm to protect civilians. The Italians participated as well. This is less famous than Guernica, but two bombings of Barcelona during the Spanish Civil War, Japanese in Nanjing, and the response by the democracies, by Britain and the United States, was what you would expect if the just war tradition were respected. That not only did they condemn the acts, but Churchill promised that his government would not bomb non-military objectives, no matter what the policy of the German government may be. Okay. Felt said something similar, criticizing the Japanese, that any extensive bombing of an area where there's a large peaceful population is unwarranted, contrary to the principles of law and humanity. The US government confirmed its position that civilians should not be bombed in unfortified cities. And if you got a chance to look at the article I sent you, you'll see that these are basically the principles that were in the draft treaty on air warfare from 1923 that was never adopted by states because they saw the technology on the horizon and they didn't want to limit their possibilities, but the principles still were in the air somehow, enough that the leaders of the United States and Britain would know about them. Then came the German bombing of Coventry. Now, Coventry was a big automobile and military production center of Britain, a legitimate military target probably, but it was the cathedral that was hit. We still don't know how intentional that was. The British have left the ruins there. Has anyone been to Coventry? Yeah, it's a nice little town, bicycle museum, like a car museum, I think, and a modern cathedral next to the ruin. So to commemorate the memory of the war, but also have the cathedral there again. The main turning point for the British was the Battle of Britain, the Blitz, in which something like 43,500 people were killed. So that's a large number when we think about subsequent large numbers of civilians killed, although over several bombings. But it clearly influenced the British thinking, and the views changed to the point where the Allied leaders began targeting German civilians deliberately to undermine morale in this way that Dewey made us think would work. It didn't work, right? The war lasted for many more years. Churchill, who is considered to be a very eloquent user of the English language, has this funny formulation here where he talks about the life and economy of that guilty organization. And you can't see in the antecedent what guilty organization he has in mind. He seems to mean Germany and the German people. And that was certainly the way the war was carried out. He also applied this approach to Italy. In order to force Italy out of the war, he threatened that Italy will be seared and scarred and blackened from one end to the other. So again, and they had an expression that they used, this homely expression of dehousing. So they would bomb industrial areas where there were legitimate military targets, but with the expectation that lots of civilians would be killed. Incidentally, they tended to be the civilians who were most opposed to the fascist regime, the industrial workers of Milan and Genoa and Turin. Dresden has become famous because of the fire bombing that killed so many thousands of people. Tokyo, just over one night, 100,000 people were killed with incendiary raids. What's distinctive about Hiroshima and Nagasaki is not the number of people killed, but the fact that it was one bomb each that did it, and that the consequences went beyond the immediate killing with the poisoning of the environment and radiation sickness and so forth. What's especially discouraging in this history is that it didn't end with the end of World War II. The Korean War was also a war of massive civilian casualties and bombing, even as General Curtis LeMay admits, among the people that were supposed to be defended. So the Korean War had elements of a civil war and a guerrilla war. And so the supporters of the communists in the South also were victims of US incendiary bombing. Vietnam, also famous for its carpet bombing. The Soviet war in Afghanistan was also extremely harmful to civilians who were considered supporters of the Mujahideen. This history doesn't include a couple of elements. We could call it the pre-history because air power was used, including by Italians, in colonial areas to repress rebellions. You have a quote in my article from Churchill, who thought it would be a good idea to use poison gas in Iraq against uncivilized tribes. There was also some limited experience in World War I as well, and even use in the United States of air bombing, incendiary bombing to destroy a prosperous black district of Tulsa, Oklahoma in 1921 with surplus airplanes from, this was a private initiative most, by the way, not a government initiative. Now we have the government claiming to use force in our cities. This is a precedent, if you like. Nevertheless, some scholars have argued that there has been a trend since around the time of the Vietnam War for militaries to pay more attention to harm to civilians. They have been lawyered up, as they say. So every target by the US Air Force will typically have some kind of legal judgment being made about whether it is permissible or not. We have a tremendous growth of non-governmental organizations, including some that were originally focused on human rights, Human Rights Watch, Amnesty International, getting in the business of warfare and trying to restrain it by paying attention to international legal norms, plus the International Committee of the Red Cross, whose official mandate is to do that. And they have produced a lot of good treaties banning weapons that were considered normal weapons in the past, but are now subject to treaty bans. Even before those weapons were banned, like cluster munitions, there were campaigns to stigmatize their use, and then they eventually became part of an international treaty. But what about US policy? This is an argument that Nita Crawford makes in a volume that she contributed to. She looked at US planning and said there has been increasing attention over the years. She's not naive about the harm that has continued, but she argues there has been an emphasis on trying to limit civilian casualties. Elliot Cohen, someone coming from a very different political perspective than Crawford, made this claim in 1995. It's highly unlikely that advanced powers will again resort to the wholesale devastation of cities and towns, whether to shatter enemy morale or as a byproduct of efforts to hit other target systems such as railroad yards and factories. So he's describing the situation in World War II, saying we won't see that again. The article was published just as Russia was doing this to Grozny and other Chechen towns, and it did it again in 1999. So it was not a very accurate prediction. Let's move now to the debates of the 1990s and 2000s. This is where I started getting interested in this topic myself, concerned about the humanitarian crisis, the genocide in places like Rwanda and former Yugoslavia, and later the so-called global war on terror that the United States engaged in following the attacks by Al Qaeda of September 11th, 2001. And it was, I would say, an exciting time to be studying international law. There seemed to be a lot of promise. There were also a lot of interesting intellectual debates about the issues. Now, I have to say, in retrospect, it seems kind of quaint. Okay, it was a luxury maybe to have those kind of debates compared to what we see now with warfare. But let's talk about them anyway. This is what I have in mind. So the Convention on Genocide, I like to, I mean, in the news, obviously, with accusations against Israel in particular, and also Russia and Russia's accusations about Ukraine that you know about. Article 2, it includes the sort of things that you would expect to be banned in a treaty of genocide. By the way, you know that genocide is a neologism created by Raphael Lemkin in 1944. A new, not a new practice, but a newly defined crime, let's say. What I like to point out about it is that the Genocide Convention is simultaneously permissive and restrictive. What do I mean by that? I mean that some elements of it encourage states to act against genocide, and others say, no, 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 that's not genocide. Okay, so what are examples? So the target has to be a national, ethnical, we would say ethnic now, racial or religious group. I argue that that is a restrictive definition. Why? What is missing? What kind of group is missing? Political, right? So we think of Pol Pot in Cambodia as a genocide. We can't avoid the word since we know what the concept is, but it wasn't directed at one of these groups. It was mass massacres on political grounds. Nevertheless, there were trials of Pol Pot and his henchmen for genocide, but it required, in a way, stretching the terms. What about this? Intent to destroy in whole or in part, restrictive or permissive? Permissive of state act doesn't mean you have to intend to destroy the entire population. You can only be destroying part of it, and still states, the signatories, are compelled to act by their signing of the treaty. This, I would argue, is also permissive. Not only do you punish the crime of genocide, you try to prevent, you're obliged to prevent it, okay? But here's the restrictive part, right? And states will argue, look, we're in a time of warfare. We have these enemies. We have these fifth columns. We are just providing for our security. A lot of people died. You know, we didn't mean it. We didn't intend it. And that is the kind of get out of jail free card that the Genocide Convention provides. What's extraordinary about the current situation, especially Israel's action in Gaza, is that the intention has been loud and clear from prominent Israeli politicians. Still, Netanyahu could do something about it by saying, that's not our policy, we're punishing those people, they're wrong. If he doesn't say that, he wants to survive politically, then the intent is there, but it is often not there or not evident. The documentary evidence is not there in order to prosecute. So that's a serious weakness, you could say, of the Genocide Convention. I just wanted to highlight these particular crimes because they're relevant to the Israeli and the Russian wars recently. Okay, so what were the lawyers doing? What was international law doing during this time? The genocide in Rwanda killed something like 700 or 800,000 people in a very short period of time. Lower numbers, but still horrific crimes in the breakup of Yugoslavia, in Bosnia and Herzegovina, and later in Kosovo. There's an excellent article that I commend to you that I've used for many years in my teaching by Mona Fixdahl and Dan Smith, where they go through the just war criteria in a way that makes it easy for us to understand what the nature of the debates were at the time, especially looking at notions of right authority, who is allowed to go in and intervene in order to prevent a genocide or ethnic cleansing. Did they have the right intention? Was it the last resort? These are the principles. They argue that not every box has to be ticked off, that depending on the circumstances, we'll emphasize one element or another, but it was a very useful framework and published actually before NATO's first war in Kosovo, but after the genocide in Rwanda. So for example, it gave us a way to understand the French action, Opération Turquoise, when the French basically said to the United Nations, we're going to go in, please endorse us. And so that gave them, in a way, the right authority. But the accusations have been they actually went in to protect the génocidaires, not to protect the victims of genocide, because they had been arming those people. And so that is a way for us to judge the morality of their action. NATO's air war against Kosovo, not against Kosovo, against Serbia for prosecuting the violence in the province of Kosovo, 77 days of bombing with no boots on the ground, so to speak. Was it legitimate according to these terms? Was the intention right? These are all ad bellum considerations, but we also have in bello considerations. Did the action make the situation worse? Did it exacerbate the refugee crisis that was supposed to be one of the reasons for intervening? And yes, it did. It potentially destabilized surrounding regions. NATO also couldn't resist returning to some of these ideas from Douhet about the impact of punishing civilians. So you have figures like General Wesley Clark, the NATO Supreme Commander, saying that we needed to bring pain to Milosevic and his people. Not only Belgrade, but places like Novi Sad that were hotbeds of opposition to Milosevic. They were bombed. Another figure, hey, Slobo, what's this all about? Again, trying to get civilians to protest against a government they had been protesting against in the hundreds of thousands for days and days, while NATO paid no attention until they started bombing them. Okay, so now we have the war on terror, another different set of considerations. The attacks themselves, obviously a crime, hijacking civilian airplanes, crashing them into civilian buildings. What about this? So Al-Qaeda declared war on the United States years before. If you think a non-governmental armed organization has the status to declare war, then you say, well, and then they attacked the Pentagon. Is that a legitimate target? How do we judge the use in bello considerations of that attack? Is this a legitimate target and a legitimate in bello use of force? I know it was before you were born, but still. Target might be okay, but the weapon was a bunch of civilians in an airplane. Okay, so a crime. Speaking of crimes, there were quite a lot of them conducted in the counterterrorism operations. A lot of people thought the cure for terrorism was worse than the disease. In some cases, this is a famous example of the US and Italian secret services collaborating to kidnap this religious figure off the streets of Milan, interrupting actually an Italian investigation into his actions. And it's the only example we have of actual convictions for this crime, the so-called extraordinary rendition. I don't think any Americans went to jail. They were long gone. But still, the point, it was encouraging, I think, for people who thought there should be some consequences for these crimes. There were no consequences for these crimes. The use of torture, the Secretary of State back at Stanford echoed the supporters of Richard Nixon, saying when the president does it, it's not illegal. Okay. The vice president said I would do it again in a minute. The successor administration, Obama's, admitted we tortured some folks. Okay. But Obama would not hold those people to account. It was a huge missed opportunity. He made his political calculation. He used the word torture, but he wouldn't follow through. It's against international law. It's against US law. You don't need a law, actually, to know that torture is wrong. But by not holding people to account, we get Trump saying, I would do it again. And worse, we get the Guantanamo prison where these tortures took one of the places where these tortures took place, being repurposed to hold immigrants who are also held in Florida in detention camps, where a reasonable person would say they're subject to conditions that look a lot like torture. Okay, so this is a consequence of not holding criminals to account. The other big issue of the time was on targeted killings by drones. Are they assassinations? Are they a normal part of warfare or what? If you think it's an assassination, you notice that Ronald Reagan in 1981 had an executive order against assassinations, almost immediately tried to assassinate somebody, managed to kill his child, but Gaddafi escaped. You had the US ambassador to Israel criticizing targeted assassinations because Israel was doing a lot of that sort of thing. And then it becomes US policy, including going after US citizens. This guy, Anwar al-Awlaki, who was considered a main propagandist for Al-Qaeda. Can you kill someone for propagandizing for Al-Qaeda? Probably not. So they argued, well, he also was engaged in operational planning. That makes it look a little bit more illegal, a little bit more legal, but there's no legal justification for killing his 16-year-old son a couple of weeks later in a different country while he was looking for his father. Okay, so that's the kind of thing that went on. What's the relevant law? It's the protection of civilians, because terrorists, if you want to call them that, are civilians. They're not soldiers. They don't have what's called the combatant's privilege. What's the combatant's privilege? It does affect your status if you're captured. What's the most important privilege that a combatant has? Right, you're allowed to kill someone if you're a soldier in a war and not be charged with murder. That's a pretty good thing if you're killing people. But people who are not combatants, legitimate combatants, are civilians and afforded protections unless and for such time as they take a direct part in hostilities. So if they're engaged in hostilities, they become a legitimate target. So like a lot of these legal issues, there's a gray area. So here's a former CIA lawyer who says you can't target someone just because he visited an Al-Qaeda website, but you also don't want to wait until they're about to detonate a bomb. It's a sliding scale. And that's the way a lot of these legal debates go. He goes on to say, so if it's Osama bin Laden in a house with a 4-year-old, most people would say, go ahead. So it's a proportionate killing. You don't want to kill the 4-year-old, but you do want to kill. What if he's in a school? Most would say not do it. You see why I'm calling these debates quaint, if you think about the situation in Gaza, and if you think about the situation. We don't see people worrying about these anymore. This was an advisor to the Secretary of State. we were going after 14 senior al-Qaeda leaders, but we've killed 700 Pakistani civilians. That does not look like a proportionate use of force. At one point, the United States started declaring all military-age males in a strike zone as legitimate targets. They even gave them an acronym, MAM. You know you're in trouble when they have an acronym, okay? So people in an area known for terrorist activity, they're probably up to no good, okay? That is a far cry from legal requirement. They have to be directly engaged in hostilities, okay? There's a different kind of proportionality in terms of the target list. So the Guardian had documents from 2012 to 2013 finding that there was a list of 41 people that the United States had on a target list. They managed to kill 1,147 other people trying to get these ones. And then they decide, well, it's okay. They weren't our intended targets, but they were bad guys too. Another acronym, enemy killed in action. Okay, so this was the nature of the legalization of the counterterror war in the 2000s. A further problem is, so we've been talking mainly about in bello violations, killing civilians disproportionately, that kind of thing, but it bleeds over into the ad bellum, and that's because there was not a recognized armed conflict on the territory of the country where all of these killings were being carried out, namely Pakistan, and later the same for Iraq after the troops withdrew, and for Syria, which was a civil war, but not one that that the major powers were legally, legitimately involved in. So carrying out drone attacks against Iranian-backed forces in Syria and Iraq, it becomes a violation of ad bellum because you're attacking a country that has not attacked your country. Remember, that's Article 51 of the UN Charter. When it's the CIA carrying out the drone programs, even worse, because they do not have the combatant's privilege. They are not soldiers. They are civilians. They're unlawful combatants. So they're breaking the law, even engaging in this altogether. There's an argument that a lawyer called Kenneth Anderson has made. He used to work for Human Rights Watch. He likes to wave that flag because he's actually been quite supportive of a lot of these military actions by the United States. He says, you know, even if in a legal technical sense, we shouldn't be attacking these people, they really are bad guys. And, you know, there is an inherent right to self-defense. We'll call it naked self-defense. And so we should be able to engage in these kinds of actions. But where does that end you up? That ends you up with Trump destroying ships in the Caribbean because they're suspected of engaging in drug trafficking. Okay, naked self-defense. Well, that seems like a threat to us, drug traffickers. So let's kill them. It's a complete violation, but not an unprecedented one, because even in the Obama era, so-called drug lords flying the Taliban were as well. So the summary for the war on terror, the counter-terror war, especially where it regards drones, is that, okay, they're legal for surveillance. They're legal if they're used legally within a legitimate armed conflict, but when they're used outside armed conflicts, they violate the use ad bellum because they're being used against countries that are not at war, that haven't attacked your country. And when they're used against suspected terrorists who are civilians, who should really be arrested and tried, then they're violating the in bello provisions of the additional protocol, one of the Geneva Conventions. Naked self-defense, it sounds appealing, but there's no legal basis for it whatsoever. If you want to read more about this, I spent a lot of time writing about it. Someone spent a lot of time translating it. I don't recommend it, okay, because these are not relevant anymore to our current situation. Really, I mean, it was a great intellectual exercise. I met a lot of great people. I engaged with a lot of wonderful students, including one who's on the panel here. today, but I just can't help but ask if it's relevant anymore because of what we have seen in recent years. Want to call your attention, I mentioned it to you, Lavinia, to E.H. Carr's classic realist study called The 20 Years Crisis, where he has a lot of interesting discussion of things that we talked about on the first day, the role of hegemony. I don't think he read Gramsci, but he read Lenin, and so he kind of drew the same conclusions about the influence of hegemonic powers on the legal order, on public opinion, on morality. He argues that law, like politics, he calls a meeting place for ethics and power, and the ultimate authority of law derives from politics, by which he means the politics of states and the major states. We'll return to this in a minute at the end. But Kenneth Anderson has made a similar argument that it's really states that determine or should determine the legal order. He complained that aggressive NGOs have been too much involved in formulating the restrictions on wars, and that the pendulum has shifted too far. It should go back to the state practice of democratic sovereigns that actually fight wars. Because if states that fight wars become cynical about the restrictions non-governmental organizations are imposing, they'll ignore them altogether. Anderson's argument, it should return to the democratic sovereigns, like these democratic sovereigns, but they're not the only ones who fight wars. We have non-democratic states that also fight wars. So should they be defining the laws of war for us? That would seem to be an implication of what Anderson is arguing. So here's the question that I pose to myself that makes me wonder, should I be doing this anymore? And I answered myself, no, probably not. I mean, my friend invited me to come here, so I thought I would do it one more time, but I really have my doubts. What do I find that is so discouraging about this is that I can't teach this topic the way that I used to. Okay, I used to acknowledge that there's a big gray area. Who actually decides, I mean, before the International Criminal Court, or even with the complementarity element of the International Criminal Court and the Rome Statute, who decides whether these violations are taking place? You know who? States. The states that carry out the war get to decide whether their soldiers and officers are violating the laws or not. But I used to say, well, lawyers like to point to extremes to talk about, to get to understand what the principle. So, for example, if you're in a war and your enemy has a tank factory in a city, that's a legitimate target, even if you expect that some civilian workers, their families living nearby, will be harmed. The proportionality calculation says it's probably okay. Okay, what's the other extreme? The example I used to use is you have a sniper on an apartment building, you need to disable that sniper, so you destroy the entire building and everybody in it. That would be an obviously disproportionate use of force, and you see where I'm going with this, right? So the changes to the Israeli rules of engagement allowed the dropping of these 1-ton bombs made in the USA on military infrastructure, as well as fighters, lookouts, money changers, and because there was a vast underground tunnel network, anything in Gaza, right? A camera, okay? It's okay to destroy a hospital because there's a camera in it. It was a Reuters camera. It wasn't even a Hamas camera, okay? And then you bomb the hospital a second or third time as the first responders come in, which is again a violation. So it's violation piled on violation in that war. The Israelis themselves have identified a 83% rate of civilians versus legitimate military targets. Nobody would call that a proportionate use of force. We took the gloves off. Not once had legal advice constrained Israeli military decisions, the commander admitted. And so what you end up with, right? Nothing, just rubble and environmental devastation for as far as we can foresee. Russia, very similar violations, okay, attacking maternity hospitals, attacking churches, schools, apartment buildings, clearly, deliberately violations of the in bello principles and in the invasion itself ad bellum. With these kinds of civilian consequences, and then added, as you know, and this is what Putin was put on trial for before the International Criminal Court, kidnapping Ukrainian children and bringing them back to Russia and propagandizing. And if that's not bad enough, both of these belligerents. So again, to remind you, the elements of the Genocide Convention that have caught our attention, the latter one because of the Russian practice of kidnapping children, the earlier one, C, because at a minimum, that's what's happening with the Israel Gaza. We don't think that these leaders will join Duterte in prison and on trial. It's nice that Duterte is there. It's not so nice that he has vast popular support still back times. So I'm going to return to Carr and suggest that the ultimate authority of law derives from politics, but politics is not only state power. Okay, so I'm trying to encourage myself here a little bit too. And I see that on Friday you have sessions devoted to popular opposition to war. So I think that has to be the way to go. I mean, you can still appeal to international law. This is David Courtwright's monograph looking at the actual effect of peace movements. You can appeal to international law. Lyndon Johnson, a war criminal, nuclear weapons immoral. I think we'll probably have these slides available anyway, but nuclear weapons immoral, and we almost got rid of them in Europe in the 1980s, and the current movements against war for a ceasefire and my hope is for popular movements, not for international law by itself. I don't think anyone thought international law could stop war by itself, but clearly it not, and maybe popular movements can. Thank you.